and the grow dispensaries.
Oh, okay. Question, if the house has a grow operation, and another very common question, what do we need to do? There's nothing illegal about it anymore. You don't have to count the plants to make sure it's less than 12 or less. Don't do anything like that. The big place, frankly, is on leases. I have a provision, no cats, and then no cannabis sale or production. The house, I don't know if any of you have gone into a grow production house before. Let me give you an example. 8-bedroom, okay, was where they used it. Now, if the cat got in there, okay, it's going to cost you $700 to $1,000 to sand down the floor and reseal it and all that. With cannabis, it's the floor, the ceiling, the walls, and replacement of all the electric fixtures. Because when you turn, may look great, you turn on the light, and 10 minutes later, what is that smell? Because it gets into the electric, the light shades and the bulbs, all that. And as soon as it gets hot, that room stinks. You're looking at about $3,000 to rehab a cannabis room, cannabis grow room to make it usable. So as a landlord, I don't want that, period. So I have they said, I've always had a no cats. Now I have a no cannabis sale or production clause.
So, HOA, you can't have a dog bigger than 35 pounds or a pet. Isn't that like weight discrimination?
Well, not according to the courts. Okay. Not according to the courts that have ruled so far. Okay.
So they can discriminate the HOA and the number of pets and the weight and everything.
If people want to change it, 2/3 vote can change it.
Didn't they at one point in time though say that you couldn't dictate based on weight? Because it seemed to me like quite a few years ago they could no longer do that, and then all of a sudden now.
Well, there was a mixed results from the courts.
Okay.
Now we have a circuit court decision is not binding on anybody. Court of Appeals decision is binding unless it's appealed to the Supreme Court and overturned. So you can get all kinds of results from a circuit court. Okay. If the Court of Appeals says, yep, that's the law, then it is, unless the Supreme Court says, no, it's not. So the only decisions you can cite in a brief are Court of Appeals or Supreme Court decisions because they're the only ones that are the law. If you see a brief that cites district or circuit court cases, they got a pretty weak case. In circuit court or Louisiana, you can always get a precedent you want for you because it's still French civil code. And you could be the plaintiff citing Louisiana and you can be the defendant citing Louisiana, and you both got good cases. Okay. Those are, if you see Louisiana or a circuit court site, you know desperation is there. Any questions? Anything else?
Well, could you talk again about that condo land thing so I understand it again? Remember there was some restriction on the PUDs if you don't read. I don't understand that again.
Okay, under the Condominium Act, you have basically 10 years to develop the act from the date of the filing of the master deed or an amendment to the master deed. If you go beyond the 10 years, then any need not be built may merge into just become common elements so that the homeowners association owns this blank land. The act was changed in 2015 to say that the developers don't lose those rights absent a notice from the homeowners association that if they don't do something, they're going to lose them in 60 days, a 60-day notice. Now, we don't have any cases where we'll say you lost them in 13 and the act came in 15. Well, the act says it's retroactive. No court has said that, so we don't rely on it. Okay. We want the members that have bought units already to approve an amendment to the master deed to allow the continued construction. Because frankly, you've got 3 occasions that I'm personally aware of where the association said, developer, you're out. And then offered the units for sale, because it's common ground, and then tried to use the developer's documents to make them units that they were now selling. We won't reinsure those, okay? That's, you can't have your cake and eat it too in that. If you want to form another condo, that's fine, but you can't make it part of that same condo you said was gone.
And is there anything about egress and ingress and a PUD that you have to reserve if there's multiple buildings or anything over time?
Anytime you have an ingress and egress easement, we have to look at it to see whether it's singular, or that it's exclusive to one party, or does it allow for expansion of usage? If you have 4 houses on a cul-de-sac with an easement agreement going in, and you take this one here, we'll say a 10-acre site, buy 70 acres back here and try to have access for your whole development through here, that would be overburdening the easement, because these other 3 people shouldn't have to have another 25, 30 cars a day going past their house, and that would be thrown out. So we will look at each one and decide whether we can insure it based on the language to it and who has agreed to it.
If it was a public road to that 4th house, could they do it?
If it was a public road, then yes, because a public road, there is no expectation of privacy, quote unquote, or restrictive use. Now, you'll find that most condos have private roads, and there are 2 reasons for it. One is you're not subject to the drain commission if it's a condo, so you don't have to have the enclosed drains and all of that. It's probably $6 to $8 a site savings to be able to have a private road there from not having to have the drain commission sign off. Secondly, you don't have to have a 66-foot wide road. You can have a 40-foot road, and so you have more land for the condo itself. And it's a lot quicker to do a site condo than a subdivision too.
Remind me how often the developer has to redo the condo, the master deed?
10 years.
Every 10 years.
Well, if he, put it this way, if he's on top of it, he's gonna do it at 6 years and amend it to make sure you don't have to rely on the court's interpretation of 10 years versus the statute 6 years. We have what's called fractured condos, where it was partially developed and now they're selling off the remaining sites. Those are the ones we have to look at real specifically to see whether we need the current association's approval to allow the expanded building to occur again. The building to occur on the remaining units.
Well, if we have a buyer looking into a condo complex, if it's warrantable and it hasn't all been developed, is this something that we need to worry about?
Well, yes or no. I mean, I don't know. Those are specific facts and specific properties. I use an example, Clarkston Bluffs. When we developed that, there's Clarkston Bluffs and there's Clarkston Bluffs 2. The reason for 2 is that the upper level, we were approaching the end of our 10 years, and we did not want to go to the HOA to get permission to rebuild, to build more. So we formed another condo association, got another 10 years for the balance of the units. I mean, that's planning. But when we sit down with many of the clients, that's what we do. It's like right now, if anybody brings in a site condo or a subdivision plan and I read the restrictions and they say no fences, virtually all of them are eliminating it now, because you're cutting off a lot of your buyers, particularly like if you're out in North Macomb, North Oakland, Western Oakland, where the coyote problem is, because invisible fences trap the dog and let the coyote come in. And so that's so you lose all of your pet buyers, pet owner buyers. So
If it's platted, none of this applies. So if you have like a platted property, this only applies to site condos and PUD developments, right? All these.
which question?
Is my question, if you have a platted parcel, this doesn't apply?
As to what issue?
I'm sorry, the issue of having to reaffirm things in a development if the platted is not.
Subdivision is forever. A
Subdivision.
site condo, if it must be built, and they haven't built them, then there's an issue. If there need not be built, it's an issue. But facts are what control on that. But usually homeowners association approval is what I'm looking for.
Any impact on simple splits on a private road with protected covenants?
That's fine as long as you own all of the units that you're putting the splits on. And you need to make sure the access agreement is such that everybody has to kick in for it. So you don't have, because a Conrad who, got it so long ago now, 25 years ago, went to Chicago to meet with Fannie Mae. Took 4 times to finally get them to allow loans on private roads because Conrad was consul in Minnesota at a 20 site cul-de-sac, and they foreclosed on, we'll say, the 7th unit. And the homeowners got mad and they took all the snow in the winter and piled it on that site. You couldn't even see the house from the road. So that, as when they rotate their consul every 2 years and we got him next, said, that's not going to happen on my watch here. That's why we need the private road maintenance agreement and agreement to share and all that. But I finally got, it took 4 trips over there before we finally were able to even get loans done on private roads with Freddie Mae, Freddie Mac.
So retrospectively speaking, and hypothetically, if you have a private road, acreage parcels, protective covenants in place, and more than 10 years has elapsed, is there any impact on those protective covenants?
No, the 40-year marketable title act that's being looked at right now may have an effect where you have to renew those restrictions if it's at 40 years. But that's being worked on right now. It's something we're trying to get the situation where you keep the restrictions on the properties that you want to, but Detroit has a horrible problem. They've got 600 lot subs where there's 4 houses, okay? And you're trying to use it for industrial now. How do we insure it? Or can any of those 4 people oppose it and cause the whole project to stop? If there's restrictions should expire at 4 years if you read the 40-year marketable title act, literally, as it has been interpreted in other states. In Michigan, it has not been interpreted that way because if we put on there subject to building use restrictions, easements of record, okay, this citing the restrictions, not by Library and Page, has been deemed appropriate to continue the restrictions. Now, in other states, it has not been unless you cite them by Library and Page. Subject to restrictions recorded in Library and Page, that 40 years goes, another 40 years goes on. But that's still up in the air. We got another 1.5 years before we have to do something, but we're trying to get the form approved at this point.
So mineral rights, everybody checks unknown under seller disclosures. I understand in the purchase price, if they have them, they transfer. How do we know if someone has a mineral rights? Is there an easy way?
Well, typically, we're going to show that there was a reservation by a prior seller of the mineral rights. It's like I'm looking at one right now, which is an interesting one. It's 13 acres, and the seller sent back the PA with the 13 acres together with an undivided 1/3 interest in a certain oil and gas lease of record. Whoa, just a minute. That bothered me right away. Okay, we want to look at that oil and gas lease to see what kind of lease it is. Make sure it's not a wellhead where that 13 acres is worthless. Okay. Second, do the sellers have the whole thing and they're only giving you 1/3? Because you all have 1/3 rights with no vote. Because the other 2/3 will control. Okay. That to me is antlers go, alarm bells go off. A 1/3 interest. What do we have and what is it and what does it cost me or whatever? I don't know what it is.
Well, from a practical standpoint, that one company from Traverse City area came down and they got all Clintonville, they got over by the state park, they got tons of mineral rights and they own tons of them. But from a practical standpoint, unless it's above 30 acres, the township won't, this is my understanding, the township won't allow them to drill there. I guess it'd be cement drilling. or something? Is that something that I need to look at on every?
That may be
container?
something that they try to enforce, but they don't have the authority. The state has that authority.
Oh.
And it's what I'm always looking at, evaluate, if it's a wellhead, then you've got something that's a negative. If it's an oil and gas lease and it's subterranean, it's 2,800 feet down, and I get some royalties if they hit oil. Nothing wrong with that, okay? But someplace they got to go down. And it's like I was doing a program up in Port Huron, a guy that owned 180 acres, and he was planning to, or just bought 180 acres, planning to use it for recreational vehicle park. And they asked the question, I've been approached to sell an oil and gas lease, what should I do? I said, well, if it depends on the money, whether you want it, but make sure they're wellheads on the east side of the property. And he was like, what do you mean? You ever been around a wellhead? Okay. You want a west wind to take it away from your property. You put it on the west side, you're going to have difficulty selling the sites for recreational vehicles when they're smelling the wellhead.
So would they do, you transfer the property if the oil or gas rights, if you don't transfer the mineral interest, so you no longer own the, the person owns the mineral interest. Is that forever, or do they have to renew them?
They have to renew them every 20 years. They have to file an affidavit that they continue to have them.
Otherwise, they will inure to the then,
They will go to the then owner.
the
Yeah.
then owner.
Now, just as an aside, one of the big issues in Michigan, particularly in Oxford and where else? Anyway, is gravel is not a mineral if you reserve mineral rights.
Oh.
Okay, you have to reserve the gravel. It's not within the broad category of mineral rights for gravel. Oxford, that was a big issue.
Can we go back to the site condo thing for one
Sure.
second? The master deed creates the site condo complex with the developer. Few houses are developed. Ownership of the association transfers to the owners of the owners. Does that association then have to renew every 10 years as well?
No, on a site condo, okay, yeah, it's a lot easier because all of the must be built are done. The roads are in, the utilities are in. So those are complete. No, there's no 10-year, 6-year, any rule on that.
Okay.
It's if they're a structural condo and you want to build more buildings, that's where the issue comes in.
So the master deed says, it lays out, here's the sites that can be built, here's the parameters within a building can be on that particular site. Does that have to be renewed every 10 years?
No,
It doesn't?
No.
Okay.
they are good because the developer has performed all of his obligations.
Okay.
All the must be built are done. The must be built on a site condo would be the roads and the utilities.
So for site condo, it's a little bit different.
Right. Yep.
Got it. Okay.
Yeah, I will ask for something from the engineer typically in that as there's substantial completion. If they only run the sewer up here and they should be going all the way, they only run it up here, they haven't completed. Okay. They run the sewer all the way around, yeah.
Thank you.
Thank you. My pleasure.
I do have a question on the trust and Lady Bird deed. If you're